A very happy Wednesday to you. We're back from our brief summer break and welcome to our next edition of the Elville webinar series. I'm Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be your moderator today. I'm wearing my very best tie for you today as well. Our topic today is what families need to know about planning for a loved one with special needs, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. And there is nobody better to talk about today's topic than Steve, and you're in the right place for high-level legal education. We have a lot of new attendees to today's webinar, so a couple of housekeeping items. We always encourage your general questions throughout, so please note them in the chat or question section on your screen, and we'll pause periodically to address them. And yesterday by email, you received the presentation slides that Steve is going to be referencing throughout the presentation, and these slides are also available in the section marked handouts in the panel on your screen to download at this time. And for our professionals on today's webinar, thank you for being here as well. As is the case with most every presentation we offer, 1.5 continuing education hours are available for most everyone attending. And if I don't have your ID number or an accreditation yet, please send that to me if you'd like to earn CE for today's presentation. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a few minutes to fill out this very brief and simple survey and offer us your feedback about the presentation. And we read and value every comment that you have to share with us. And here at Elville & Associates, we're always here as a resource for your family and you, whether that means new planning that needs to be addressed, outdated documents that may need to be reviewed, or perhaps another matter. Steve and his team are here to advise and counsel you every step of the way here in our Columbia office, our Annapolis office, our new Rockville office, which we're very happy about, and also by video. I'd like to share with you just a bit about Elville & Associates and Steve, what makes us different from all those other law firms that you may have been working with in the past and all those webinars that you've been spending time on the past couple of years. I'll tell you a little bit about that, and then we'll jump right into the presentation. So you should be able to see my screen here. Elville & Associates was founded many years ago, 2010 in Columbia by Stephen Elville. We have several different practice areas that we focus on here at the firm on a daily basis, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 9 attorneys, 12 staff members, and 3 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. Education is a recurring theme you're going to hear throughout our presentation today, and we work on that in several ways with our clients. We do that through our planning processes with our clients. We have different programs to suit all families and individuals, and we work with hundreds and hundreds of people on a yearly basis. Also by way of our educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only a couple firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. And just a bit about Steve. His work as an attorney and our leader here at the firm for the past 23 years and 14 here at Elville & Associates has been centered in elder law, special needs planning, and estate planning. He's a member of many, many different national, professional, and membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. Steve works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned speaker and presenter. If you haven't heard him talk before, offering many webinars, workshops for businesses and their employees, speaking at conferences, and also continuing education events each year. And lastly, Steve was named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization that we've had here since 2014 that Steve founded. I'm very fortunate to be the executive director of. If you'd like to learn how we work to make a musical difference in the lives of children each day in the communities that we serve, please reach out to me and I'd be very happy to share our story with you. Today, though, we have an important topic to discuss, one of our more popular presentations of the many we offer about special needs planning. Steve, I'm going to go ahead and make you the presenter of today's presentation.
Jeff, thank you so much for that great introduction.
Oh, my pleasure.
And I'm going to get my tech squared away here, Jeff, so hopefully you can see the presentation. And let me get my presentation up, which I thought was up, but it is not. So let me get it back to where it should be. There it is. And Jeff, I hope you can see that.
I can. Looks
Very
great.
good. So I'll get my slideshow started. And good morning, everyone, as I get myself situated here.
There's a slideshow in the middle there, Steve.
Yeah, I'm looking for that, Jeff, and there we go. Thank you.
There we go. Yeah.
Really appreciate it. All right, good morning, everyone, and it's my privilege to be here with you today. I'm very humbled, in fact, to be here with you. Jeff, I can't believe it's August 7th already. So I guess the kids are enjoying their last days of summer. We've got Tropical Storm Debbie outside. All kinds of things are going on here today. But wherever you are as our special guests, we welcome you. And it's been my privilege, as I mentioned, to work in the field of special needs and elder law and estate planning all these years. And I could not do what I do without our support team, Jeff Stauffer, and the attorneys and staff here at Elville and Associates. And I could not do it without you. Persons like you who believe in education, you're looking for guidance, and we are privileged to be able to help with that guidance. So again, it's a great privilege to be with you today. And one of the things that we are challenged with is that we know, and I know from experience, that if you are the parent or relative of a loved one with disabilities, we know your time is very limited. We know you are challenged on many levels, and no situation is the same. We know these challenges vary in intensity and variety of challenges. We also know that not only is your time limited, but you don't have a lot of time to think. You don't have a lot of time to think about these issues and resolve these issues. So one of the things that I think is the biggest thing we can do today is give you some time to think, and yet your time is limited. And so we are challenged with that, and we want to provide some understanding, some substantive understanding of these issues in the limited time that we have. So that is our goal today. And again, it's my privilege to be with you. If there's something you don't understand, if there's a concept that you don't understand, I hope you will let Jeff know. He's an excellent moderator, an expert moderator, I must say, and a veteran of hundreds or even thousands of these webinars at this point. Don't be afraid to ask questions. Don't be afraid to ask us to stop and explain something. And so along these lines, let's get started. And thank you again for being here. This is not meant as a legal consult of any kind or legal advice. This is educational material on a high level. We will answer your questions to the degree that we can, very generally, but this is not an attorney-client relationship, although there is an attorney-client relationship if you actually consult with us or another attorney. That attorney-client relationship does happen at that particular moment, and there is confidentiality in that representation. And we're going to get started here, and we're going to talk about why you should plan. And obviously, there's many reasons for planning. But before I get right into the presentation, and I'm going to be efficient, I'm going to end on time, and we're going to take your questions throughout. But I want to check in with you. I know some of you are, let's say, families that are dealing with someone with a brain injury or other disability, or an intellectual disability for your loved one. And you have various situations. Some of you are married, some of you are single, some of you are retired, some of you are still working. You may have come here today to get information or to learn more for various reasons from all walks of life and wherever you may be coming into this webinar today from. I want us to take 60 seconds, not much time, to really just check in. Why am I here? What is my goal in this presentation? Where do I feel that I have weaknesses with regard to my knowledge, even though I may have heard this before? What is keeping me from moving forward to do what needs to be done? Is it emotional? Is it a practical problem with scheduling? What is it that's really the reason I'm here today? Let's get centered on that. And I'm just going to start my clock. We're going to take about 60 seconds. And I know this is a bit unusual, but I find that it's good to get grounded before we really take in material, especially material like this. And I also want you to get situated with your pad of paper or your tablet, whatever it is, your computer, whatever it is that you may need to make notes, to write down something that strikes you particularly as interesting or important, and also to think about your goals. Remember, all planning is goal driven, GOAL. And I'd also like to thank our professional advisors, CPAs, and other collaborative professionals that are on the call today. We'll go about another 10 or 15 seconds and we'll get started. Okay, my timer tells me that the 60 seconds is over. Let's now get started. So you're going to have lots of reasons why you want to plan for a loved one with disabilities, whether you're a parent or grandparent or other relative, but it's really about enhancing that person's quality of life to the maximum extent possible and not restricting their potential. Now that makes sense, I hope, and you'll have your own reasons, but not every beneficiary is in the same situation. Not every family is in the same situation financially. And there are families of wealth, let's say, that might not be planning for the same reasons for public benefits and other reasons as another family, which represents, the majority of families are planning around public benefits and enhancing the quality of life around that, but not everybody. So we want to keep that in mind. Providing financial security, understanding and leveraging public benefits, which we still have. And there's no indication to think that we're not going to have that, even though many people have concerns about the political cycle, the political winds, what that may mean to public benefits. But some of us have been around quite a while and have seen quite a few things transpire. And of course, anything can happen. And we need to be aware of these issues. But I think we can still have confidence in our means-tested public benefit platform that has been around for many years to support our loved ones with disabilities. Lifetime management and housing, advocacy, these things kind of blend together. Where will my loved one live? We know many of you are concerned about this. Some of you have already got this figured out. You already have a plan for appropriate housing. But many of you don't have a plan for advocacy, which we understand is a very difficult issue. Lifetime management, caregiving needs, how is the extended family going to react? Some of you are extremely blessed with family members that are going to step up to the plate. Others of you do not have that ability. But we're also protecting the beneficiary from creditors and predators and fraud and abuse. And some of you would like to plan in a very efficient way to preserve assets for others in the future. All of these things and more are going to be part of why you are here today, or to find out more about planning, or for some of you who have already done planning, to revisit that planning. And that's part of good estate planning as well, is to revisit old planning. Now, I'm going to be intentionally redundant, as Jeff and I many times are on these webinars, for the purpose of not boring you, but for the purpose of trying to emphasize certain things over and over that we hope will, kind of get out there into your brain as you write these things down. We want to have a great team of advisors for your and advocates for your loved one. What do I mean by that? Well, we're going to get into that more. We want to build in flexibility. I think we all can agree we live in a changing world. I think the world must have changed just in the time I've gotten to work this morning. That's how much change is going on in the world. The advisory team, this collaborative team of advisors, We're going to talk about this. Could include a CPA, attorney, financial advisor. Could also include a life care manager or advocate. It could include an insurance professional, just to give you some basic ideas as we go through. A trust protector for flexibility. We're going to get into that a little bit more later. For those of you, many of you have not heard of that term, trust protector. This is something that you can build into your documents as flexibility for the future for your loved one. It is not required. We're going to talk about this a little bit more. So let's talk about how to create an effective plan. This is a lot of information. We're going to try to get our arms around it within an hour or so. So planning makes the big difference, right? We talked about why are you here today? We talked about what is planning in your mind. We want to use our imagination. What is the future? And how do we even address this with the pressure that we know many of you are under? Take the time to think. Well, that's easy to say, but we do need to take the time to think. Where will our loved one live? What kind of care will be required? Does our loved one have or need a guardian? Who else will be involved? Who is in this planning team, as I mentioned earlier? What kind of lifestyle do I want to provide for my loved one? What is their lifestyle now? Is it kind of on autopilot because of public support agencies and so forth? Or is this something that's going to have to be articulated and designed by you? What are the future challenges that could happen? We talked about the political winds. We talked about whether means tested benefits are available today and in the future. Well, in any event, we want to build layers of protection, layers of financial wherewithal, layers of advocacy, and so forth. And we need to understand our purpose, our goal as we enter a process. Now, we could talk for an entire hour about process, which I won't, but having a process is extremely important. Estate planning and special needs planning is delivered today either as a transaction or as a process. And you definitely don't want to be a transaction, especially when it comes to your loved one's estate planning for special needs planning. So we want to have a purpose and we want to have a process that includes education, as Jeff mentioned. Creating a memorandum of intent. This could be one of the biggest things that makes your particular planning for your loved one or loved ones the most impactful. Creating a memorandum where you're talking about your loved one's preferences and goals and wishes and what are they really like? What are the activities that they have in their life? Who are their advocates? Who are their physicians? Who are their caregivers? This is one of the biggest things, I guess, that could make the planning most personal to you and to your family and your loved one, but it's the thing that takes the most work, and it's the thing that takes an absence in most planning. So I would say the vast majority of planning has no memorandum of intent. This is an opportunity for you to work on something substantial. We have templates for this we could help you with if you would like to receive one. We also can advise about more robust types of memorandums where you could create a binder or a folder of information, not just a memorandum that could be attached to a trust. So this is a big thing. I want you to write that down. We need to estimate the kind of expenses that are needed in the future. Now, many of you do rely, and rightly so, on the means tested programs that are out there. But nonetheless, I think as you look at this situation, you should do some estimating. You should use the resources of financial advisors. It's been my experience that many families with a loved one with special needs or disabilities do not have the appropriate financial advisor. They just haven't had time to do it, or they are not satisfied with their current advisor. So there are probably advisors on this call today, good people who are interested in helping families with disabled loved ones. We want to use their resources. They have resources where they can project. They can help with insurance planning. They can help with allocation of assets and how to get from where you are to where you want to be, not only for your personal sake, but for the sake of the planning for your loved one with disabilities. These are some old school materials. You can go on the internet and get better materials. Start thinking about this issue. Use your financial advisor resources that are available to you. And if you don't have a financial advisor, you don't have a CPA, if you don't have a collaborative team, and you say, Steve, what in the world is that? I need to get that. We are here to help you, get that information so that you can make decisions about getting these people involved in your planning. Now, your loved one is either a loved one with disabilities that does not have the mental capacity or competency to have their own self-determination by way of an advance directive or power of attorney, and maybe they need a guardianship. And on the other hand, we have guardianship, which is the complete loss of rights. And fortunately, we are living in a world where it doesn't have to be one extreme or the other. We now have supported decision making, which is a substitute for guardianship, but it's also an enhancement of your loved one's ability to have self-determination. And the law is fairly new in Maryland, and it's relatively new in the country. So this supported decision-making law, it's continuing to develop. It has its challenges. It has its challenges for many of you about understanding it. So we're here to help you try to juxtapose, I would say, the right of self-determination. Your loved one can sign their own powers of attorney or advance directive, or they cannot and they need the protection of a guardianship. And many times guardianship is necessary and it's important, versus avoiding guardianship and coming to terms with supported decision making and its ability to allow a person the greatest degree of self-determination under any circumstance. So this is what we're dealing with, and it's not an easy thing to think through. We are here to help you think through it. Now let's talk about trustees, and we're going to get to the issue of the trusts for special needs that you should understand the information about. But let's talk about public benefits, and this is just an example of, as you think about planning for your loved one, you think about a supplemental or special needs trust for your loved one, you have to choose trustees. You have to think through the future. Who will be the trustee of my loved one's trust? And many of you know the answers to those questions. Many of you do not, and this is one of the most important things today in planning throughout the country. Who will be the trustee of the trust that I will leave behind for my loved one? And so one of the things I want to point out is that most trustees do not understand these issues. They don't understand public benefits. They don't understand advocacy. They don't understand bill paying and record keeping and financial advisory advice and how they should properly manage trust assets. They don't understand these things. So we offer a webinar on how to choose a trustee. So if you have some extra time and you would like to watch that, Jeff will be glad to provide you with that information. But the thing to take away from this slide as we move on now expeditiously, the thing to take away from this slide is trustees do not understand these issues generally. I'm going to give you the name of a book, and there's several books out there. I like this particular book because it's very comprehensive and it's very easy to read. It's called How to Administer the California Special Needs Trust. Now, that's a surprise, right? And we're not talking about California, Maryland, even though there is a California, Maryland. We're talking about California. But the person who wrote this book, Kevin Urbash, U-R-B-A-T-S-C-H, U-R-B-A-T-S-C-H, Kevin Urbash, the former president of the National Academy of Elder Law Attorneys, the National Academy of Special Needs Attorneys, That person is a very, very good special needs attorney and has written this beautiful book where if your trustees will read that book as part of their duty, they will have a good idea about public benefits. Let's look at this chart. This is one of the most important things I could share with you today. Many of you have a loved one who is on SSI on the left side, supplemental security income. And as a result of that, they receive medical assistance or Medicaid. They are in the Medicaid system. This left column is the quintessential means tested benefit that a person with disabilities receives. Many of you have young children who have not yet reached age 18 and are not yet on SSI. The thing I want you to take away from this particular slide is, on the left is the quintessential definition of disability, and that is a certain amount of money. Right now, it's a little bit less than $1,000 per month. It puts your child in the position of receiving, or your loved one in the position of receiving medical assistance. But if that child was disabled prior to age 22, they were disabled prior to age 22, many parents and loved ones do not know that that child is a disabled adult child, which we're going to see in just a few minutes. And when the parent of that child retires or dies, God forbid, that child will switch from the left column into the middle column. They will receive Social Security disability, not on their work record. Maybe they do have a work record, but probably they do not in many cases. They will get the Social Security disability benefit on their parents' work record, and they will receive, in many cases, not all, Social Security disability, Medicare. Remember that that person will get Medicare within 24 months, but they will also receive Medicaid if they are still in these underlying public benefits that are means tested, such as DDA waiver benefits and other means tested programs. So to reiterate, a person who is receiving SSI, if they are disabled prior to 22, will receive Social Security disability and make 50% of the amount, 50% of the amount of their parent, excuse me. And if the parent dies after retirement, of course, the loved one, the disabled loved one, will make 75%. So 50%, they'll switch from SSI to SSDI as a very general rule, very broad. There are exceptions. And then they will receive 50% during the lifetime of the retired parent, when the parent retires, and 75% when the parent dies for the rest of their lives. So this is a very big thing that many of you are not aware of. Now you at least have some fundamental concept about that. We're not going to talk about Section 8 and veterans benefits too much today. The only reason I put that up here is if your loved one is in housing that is HUD housing or Section 8 housing, that represents a little bit of a challenge for special needs trusts, which we could talk about on an individual basis. But I want you to look at this public benefits at a glance, SSI versus SSDI. Now let's go back to the middle column before we go away from this slide. What if the loved one with disabilities, and there's many people like this, they do have their own work record and they are receiving SSDI, Social Security disability, based on their own work record, okay? Then that means they're probably not a disabled adult child. They probably weren't, or in some cases, yes, but many cases, no. They were not disabled prior to age 22. Well, we know Social Security disability is not means tested, but the underlying Medicaid benefits are means tested, especially waiver benefits and so forth. So where I'm going with this is, as we lead up to the discussion of special needs planning or special needs trusts, this is basic fundamental information that our trustees and we as loved ones and advocates, we need to understand public benefits. So I'm not going to spend a lot of time on this slide. This is a test for SSI. You can read this in your own way and time. Disability definition. This is very important information, but not necessarily to our presentation today. We know that the resource test for SSI is still very low. The individual cannot have more than $2,000 in their name, $3,000 for a couple. And I've actually seen situations like this. They can own a home of any value and a vehicle. It doesn't mean they should own it. Perhaps their trust should own it, but they can own these things and still get the quintessential definition of disability, SSI. Now,
Steve,
here we talk, go ahead, Jeff.
can I pause for a brief question related to
Go
this
ahead.
subject? Thank you. Question is, I was told that the Social Security Administration looks at the parent's income if the person is a minor. Is that true?
Yes, that's an excellent question. Thank you for giving us that question. There is a way, most of the time this is not the case, but there is a way for a child to receive SSI prior to age 18. and that is if they are in an impoverished household that does not make enough money, then that child can receive SSI even though they have not reached age 18. And I believe that is the nature of the question and the situation that you're probably describing. But that is true. Thank you. So here we have the 2024 benefit as $943 a month. Long story short, this is not very much money. It certainly doesn't provide for what we really need in the world today in 2024, but it is not something to take lightly. And studies have shown that unless a person with disabilities is receiving a rather large amount in their special needs trust, and I mean a very large amount, then this SSI is very, very important because it accumulates over time into a large amount of money, and it is the means tested equivalent of this person getting Medicaid. And so this is a very important thing for many, many beneficiaries, and many of you have dealt with this and are dealing with this. Your loved one cannot earn more than a certain amount of unearned or earned income, or they will lose their SSI. That's what the basics of this slide is meant to convey. We don't have time to really get into this formula, but just realize that if your loved one on SSI is earning income, either earned or unearned income, we have to be concerned about the reduction of the SSI to zero, and we don't want that to happen because that could cause a loss of benefits. Some of you have a loved one living at home with you, and that person is not paying rent. They are simply living at home. They are receiving food and shelter, living with you, and so you are giving that person, that loved one, in-kind maintenance and support, just to give you a real quick example of these slides. And that means a reduction of 1/3 of the Social Security benefit. So there are ways of dealing with this. So if that's the situation where your loved one is losing 1/3 of their maximum benefit, we can fix that, and please contact us and we can help you very easily get around that problem. SSDI, Social Security Disability, we know this is not means tested like SSI. We know that a person could have $1 million in the bank and still get SSDI. They're injured or they're disabled and they are receiving this. But we know that just as per that slide we looked at just a few minutes ago, many people are receiving Social Security Disability and they are receiving what I would call underlying means tested benefits, such as waiver benefits. So the person who is receiving Social Security Disability may very well need a special needs trust or supplemental needs trust, as you'll see here in a few minutes, even though the SSDI itself is not means tested. We talked about the disabled adult child benefit. This slide describes that, and this is one of the most important things for many of you today to walk away from, to understand this, which is a very positive thing for most people. Medicaid and Medicare, these are slides that are meant to convey substantive information to you, but is kind of beyond the scope of our discussion today. It's more informational for you. And we talked about Section 8 housing and how this can cause some issues about the distributions from special needs trusts. And we know that there is something called ABLE, and if you have an ABLE account for a qualified loved one, this is a way to get around some of these problem rules where we need to distribute money to an ABLE account that can then distribute for the benefit of your loved one, and believe it or not, get around some of these onerous rules. All right, so that is leading us to housing. We were just talking about Section 8. Again, for many of you, you're very concerned about this issue, and I completely understand. Is my child already situated with a place to live? Am I happy with that? Is this a long-term residence for my child? Or is my loved one not really situated yet in housing? They're still living with us, let's say, with you. And are you going to leave your residence in a further trust, like a special needs trust for this child? Is your child able to live with supports in the residence that you leave them? Do you have flexibility built into your planning about housing? All of these issues are counseling issues and they're design issues in special needs planning. All right, So I'm looking at my clock, and we are about a little bit more than halfway through the presentation. And I'm just going to keep going until Jeff interrupts me again. Let's get into now why many of you are here, which is to learn about special needs trusts. And I'm going to say that as a very broad term, we use that term special needs trust. But you're going to hear me mix in the terminology that you already heard, a supplemental needs trust. So let's take a look at this first column going from left to right here. The bread and butter of your estate planning for a loved one with disabilities is what we call a third-party supplemental needs trust. That's a mouthful. A third-party supplemental needs trust. And that's because you as parents or grandparents or concerned loved ones, you are third parties that are leaving money for the benefit of another person, the person who is disabled. So your third-party trust, your third-party supplemental needs trust can be established by basically anyone other than the beneficiary. And upon the beneficiary's death, so the beneficiary hopefully will live many, many years, live a normal life, but after their passing, the money goes where you, the grantor of the trust, say it goes. So here we are providing third-party money. The money comes from point A, the third party, to point B, the trust for the person with disabilities. Notice that the person with disabilities, I would say, is point C, and the money is not coming directly to them. It is going to a third-party trust for them. And so this is the concept I want to give you. And upon the death of that person, God forbid, many years from now, that money will go where the grantor says it goes, not to the state of Maryland or not to the state of New Jersey or wherever this person may be living in the future. So the third-party supplemental needs trust, we're going to look at a few more slides about it, but that is the basics, the basis of a solid estate plan for most people, for a loved one with disabilities. Now, the next two columns are what we call first-party trusts. And if this makes no sense, you are not alone, so do not beat yourself up. Let's pretend that someone died and left money not to point B, which is the third-party trust. They left money straight to point C, the disabled person. Or let's say the disabled person was injured in a car or train accident, injured at birth, injured in a surgery, God forbid. This person is receiving a settlement or they're receiving an inheritance directly. So these last two columns here, D4A, what in the world is that? That D4A is in the United States Code, the United States Code. 42 USC 1396P, 42 USC 1396P. This is the United States Code that breaks out these types of trusts. So the D4A trust is a very popular trust for a person who does receive funds like that, and this is a payback trust. The D4C trust is a pooled trust, P-O-O-L-E-D, a pooled trust. So it's a different version of a first-party trust, but it is more of a nonprofit organization that has established a pool. So these are two different kinds of trusts, and they both have paybacks to the state. So remember that we want to plan for our loved ones with a third-party trust. That's part of our basic estate planning for loved ones. And the D4A and D4C trusts are first-party trusts. We can always use those if we have to, but our standby, our foundational planning is the third-party trust. The third-party trust is the best method of leaving assets for a loved one, and it's because the third-party situation is a loved one is establishing the trust, and that loved one is leaving assets to that trust. Now, can other loved ones leave assets to the trust? And the answer is yes. Let's say this loved one over here left a life insurance policy or a retirement plan, they can leave assets to that trust as well. Now, I'm going to talk very directly about this slide. I'm sure we don't have anybody on this webinar today, Jeff, that would do this, but Just remember, these are huge mistakes when it comes to proper special needs planning. Do not leave an outright inheritance to a person with disabilities. We all kind of know that, but yet we still see this. So the reason that the D4A trust or the D4C trust exists is because what if the person receives money they were not supposed to receive? So now we have to do something with it to save their public benefits. So this is a big mistake. It's best not to do that. What if it was left to a trust that's really not a supplemental needs trust? What if a person innocently, and I've seen this so many times over and over, an innocent person, an innocent family creates a trust that they believe is a supplemental needs trust, but it really isn't. It was not drafted properly. It is really a general needs trust. Well, now we've got a situation where that is going to cause the loss of benefits. So we have to be very careful about that. Disinheritance. I'm just not going to leave my loved one any money at all. Well, we don't want to do that for the following reasons. We left it to another person. We left that money to a brother or sister or another relative. Well, that was good. You had good faith about that. They have good faith and good intentions, but look what could happen. They might have creditors. And what if the money was lost to creditors? What if they were to die and leave the assets to someone else and they never thought about it because, gosh, I didn't think I was going to die, but now the money went to someone else who's never going to use it for the benefit of your loved one? Or what if after you leave the money to another sibling or someone that person decides they don't want to take care of your loved one anymore? Or they got divorced, and Jeff, I'm going to add another one. What if Uncle Sam was owed money and Uncle Sam came in and took the money from an account? So these are very, very costly and risky mistakes. I know you won't make these mistakes. Now, back to the third-party trust again. The beneficiary didn't create the trust. It's not the beneficiary's money, and the trust holds the money of another person. So the government says across the country, well, this is a third-party trust. This money can be used for the benefit of the person for their supplemental needs, and it does not destroy or affect that person's public benefits. And remember, we have to do that correctly, and if we do, it's not difficult, and now that money is protected for their benefit, for their supplemental needs. It protects them from the claims of creditors and all of the things that come with the protections of a supplemental needs trust. There's no payback to the state of Maryland or any other state. The funds can go wherever the grantor says at the death of the loved one, and it can be revocable. It does not have to be irrevocable during the lifetime of the grantor, and we want to build in flexibility. Jeff, I'm going to switch gears here and be efficient and keep going. I will keep going unless there's any questions. So choosing a trustee, we talked about the very, very big issue of choosing trustees. This could be a family member. It could be a professional. It could be an attorney. Let's say that a family member did not serve as trustee. Well, maybe the family member might be an advocate or a trust protector in the special needs context and not just a professional as a trust protector. So in other words, many families are going to think in terms of my family members are going to act as trustees. But that's a counseling issue. Maybe that's not the greatest arrangement. Maybe there should be a professional trustee and the family member serves as an advocate. So this is really just an issue of counseling, sitting through reviews of documents and really coming up with ideas and epiphanies about what is the best approach. We talked about a trust protector. I'll start with that at the bottom of this slide. The trust protector idea has been recognized in Maryland since 2014. What is a trust protector? Well, a trust protector is a special fiduciary, a person of high responsibility that has the ability to change trustees, has the ability to amend the trust administratively or make modifications if there are changes in the law, review an accounting because your loved one with disabilities, let's say, can't appreciate their own accounting, provide flexibility for the long-term future, remove a bad trustee if there was a bad trustee involved. So this takes a little bit of getting used to, but I strongly recommend for people who are developing trust to use the idea, use the concept, the tool of a trust protector and to learn more about it. The Trust Advisory Committee. Some of you have loved ones with mental health issues or more significant issues that might affect the willingness of the beneficiary to cooperate, or the ability of the beneficiary to basically be taken care of by a trustee in the proper way. And sometimes our loved ones, no matter what their disabilities may be, they might have challenges with distributions or the public benefits they receive, and what is the best path forward. So another possibility is to include a provision in the supplemental needs trust about an advisory committee. The physician or the service coordinator or the advocates and other family members that might be involved in a committee at times that needs to advise the trustee about what to do. Let's take a look at this circle with the concentric circles a little bit here, not really concentric, but these are, I think, a representation, these circles, of the kinds of things that can be done in contemporary special needs planning. Now, do you have to have a special needs or supplemental needs trust that really has all of these features? And the answer is no. If you have a supplemental needs trust that is plain vanilla, it basically is just a foundational supplemental needs trust that says it's created under Maryland law, and it's created under the Maryland Discretionary Trust Act, that is going to be okay. But the question really is, have we really considered everything that's going on out there today? Flexibility, so there's the trust protector on the left. The existence of the Maryland ABLE program, and do we want the trust to be able to make distributions to the ABLE plan? An advocate, have we really talked to the trustee through the document to say, this is how we feel about advocates. We want you to hire an advocate. This is not a question. We want you to understand that this is part of your fiduciary duty to hire professionals. The memorandum of intent, it's certainly not required, but does it give substance and life to an otherwise very bland document? And the answer is yes. And it is a lot of private information, but the question is for you to think about, how much information do I want to share and what would be my purpose? And obviously it's to try to enhance the quality of life of the beneficiary. We talked about the Trust Advisory Committee, special retirement plan provisions. So many of you are familiar with your own retirement plans, your IRAs or 401ks or 403bs or 457 plans, those qualified plans. But when we die and we leave assets to a supplemental needs trust, and if the beneficiary is definitionally defined as disabled under Social Security, for example, that beneficiary is exempt from the Secure Act. The Secure Act is that legislation from 2020 that says our healthy children, our healthy beneficiaries, they have to take all monies out of an IRA within 10 years. They have to pay the tax in 10 years, but not your loved one with disabilities who is qualified as an eligible designated beneficiary under the Secure Act. So a good supplemental needs trust, in my opinion, will talk about the Secure Act and talk about why your loved one with disabilities is exempt from the onerous Secure Act, and they do not have to pay all the tax within 10 years. So this is part of thinking through the design of a trust. So we just talked about the Secure Act. These are the 5 exempt types of individuals who are exempt: surviving spouses, minor children, disabled persons as defined, as I mentioned, chronically ill persons who might have a supplemental needs trust, for example, and a beneficiary who is not more than 10 years younger. That's a strange one. And what this is basically saying is, if we recognize this and your fiduciaries are informed and educated, our loved one with disabilities will not have to pay tax all at once within 10 years, basically, and they will be able to stretch out the taxation. If they don't need the money, they can stretch out the taxation throughout their lifetimes the way most people used to be able to do prior to 2020. All right, let's shift to the trustee duties. Now, these are the concentric circles I was talking about. This is what we're really looking for. And Jeff found these photos of people who just look like really have got their act together. These trustees, they know how to advocate, they know how to account, and they know how to deal with financial affairs. But as we're going to see here, they don't do all of this themselves. Now, of course, they advocate for your loved one. They are looking to advocate for them and their best interest. And I'll tell you, I have worked with some trustees recently who are just phenomenal in their advocacy for their loved ones, and that's unbelievable. And a perfect trustee, so to speak, understands public benefits and promotes quality of life and independence for the loved one or the beneficiary. However, do all trustees really understand these issues? And if the answer is no, which it is, not all of them do, they're going to seek professional advice. So that's a fiduciary responsibility. Accountability, as we go around the horn here. They keep accurate records. They keep the beneficiary informed if the beneficiary is competent to be informed, or even close to being competent, because the beneficiary is entitled to information. And they comply with their statutory duties of notice and communication. Financially, they invest properly, but do they do it themselves? The answer is no. Unless they are a professional and financial advisor, they are going to hire a financial advisor, and they are going to get an investment policy statement, from the financial advisor that says, we recognize that you are a fiduciary and you have a special duty of responsibility, and we are going to invest the assets appropriately. That perfect trustee understands taxes, but do they do all the taxes themselves? No, they hire a professional. So that is what I want you to take away from this. The perfect trustee, or the person who aspires to be a great trustee, and that's what we're really looking for, is a person who understands their responsibility, is willing to carry out their responsibility, and hires professionals to help them. So hopefully these concentric circles are one of the most important things, other than a couple of the slides we've talked about, that you'll take away today. Many people are concerned about what a supplemental needs trust can pay for. Well, to make a very long story short, first-party trusts are more restricted because those trusts are called sole benefit trusts. They can only be used for the sole benefit of the beneficiary. But a supplemental needs trust, the third-party trust that's a bit broader, that third-party trust can be used basically for anything for the benefit of that person, and it's a little more loosely construed, but anything within reason for the benefit of that person, other than obviously gambling or alcohol or things that are not in the best interest of the person, those things are allowed. And this is a subject that we could talk about more one-on-one. How much should you fund into a supplemental needs trust? This is a family by family, person by person situation. What I want you to think about is, many of you have situations where you're going to treat all your children or loved ones equally. Some of you are not going to do that. And if you do that, and you at least do it in an informed way, you're going to be working with your attorney, your financial advisor. You might use life insurance as a funding tool. You might be a person with a lot of retirement assets, which many of you are. So you're going to take all this into consideration, and your emotions and your background and everything that you have going in your life, and you're going to decide about these issues. The one aspect is, how much should I leave to each beneficiary versus my loved one with disabilities? Another issue is, how much should I fund? And if I don't have enough to fund, can I create funding through life insurance? I want you to think about life insurance as the Swiss Army knife of estate planning. It's got all of these gadgets, it's got all of these possibilities, and it's not inexpensive, but we can use life insurance in very powerful ways if it needs to be used. We talked about first-party trusts. These are payback trusts. If a person has received an inheritance, if they have been injured, these trusts serve a very important purpose. They are payback trusts, so we want to avoid them if we need to. For example, they must be used if you are a military veteran who is receiving or will receive a military pension, and you wish for that military pension to go to your child with disabilities. It has to go to a first-party trust after your death. These trusts are important. They can be implemented by the person with disabilities. They do not have to be implemented by a court. There are various types of ways that they can be implemented. And we just talked about this. I'm being intentionally redundant by mentioning it more than once. At the bottom, I'm making a little note that in a perfect world, all parents or loved ones that create a a third-party trust, the bread and butter trust, it's always a good idea to create the first-party trust at the same time, even though the first-party trust may never be needed, it may never be used. So we just want to think about, well, maybe it's a good idea to create it just in case it ever needs to be used, but again, it's not required. That's what this slide is really getting at. So as we start to wrap up, and it's 5 till 11, what is the process? Well, this little, I guess, ocean chart, I will call this, is really trying to say that at Elville & Associates, we educate clients. We believe an educated client and educated family members, educated fiduciaries are the best clients, or not only that, but that family or that individual has the greatest chance of having their plan actually work the way it's supposed to over a long period of time. So we want to meet, we want to give you time to think, we want to review, we want to take time to, in our conference room, in our various ways of using audiovisual material, we want to give you a chance to really think through the issues over several meetings in a perfect world. Not all of you have time for several meetings, but that's the best way to do it. That's the way we do it and what we're known for, including a family meeting. So many of you will implement a program, but now we need to really meet with the fiduciaries. We need to meet with the advisors. We need to meet with everyone. It doesn't have to be a long meeting, but it does have to be coordinated where everybody understands. And then good planning is you revisiting your planning over time into the future. That is the way you can make sure that you worry the least amount and make sure that your planning works in the best way. We talked about guardianship. We talked about supported decision-making a little bit. This is a question, as many of you have loved ones that reach age 18 or beyond. The question is, do I get guardianship of my loved one with disabilities? Very personal, very emotional, and very medical driven. So this is a very sensitive issue. We want to treat it as such, and we want to have those conversations. And the right of self-determination, from self-determination all the way through guardianship and everything in between, such as supported decision-making, needs to be discussed. This leads me to a discussion very briefly of supported decision-making. And if you're not familiar with this, we want to get our minds around it. It's very new. Courts are interpreting this. We have supported decision-making agreements, meaning an agreement that we've created. The law did not provide a form or that kind of thing. In Maryland, we did not, even though the law is very broad. I encourage you to read about this through the websites that state government puts out. I'd encourage you to read my article on it, which was very early on, about supported decision-making, and also to maybe watch our webinar on supported decision-making, just to get your minds around this concept, because it is very confusing. It makes perfect sense to some parents, and it makes no sense to other parents, and we want to try to get our minds around it as the future continues to go forward. What is its promise? Its promise is to enhance the quality of life of a loved one with disabilities. Its challenges are the confusion that it causes in some people's minds. And the Maryland law went from having no supported decision-making law, even though our neighbors in DC and Delaware did have supported decision-making for many years. Now Maryland has an extremely broad supported decision-making law. So it is something to be contemplated and studied, and I encourage you to take those steps to read about it. So what do we want you to do? We want you to think about creating a memorandum of intent or a binder or whatever expression of your concern for your loved one that really kind of describes them in a more broad way, other than the legal technical side of their trust. We want you to establish your own estate plan. We want you to have a foundational estate plan, a will or revocable trust of your own, powers of attorney of your own, advanced medical directive of your own. We know that the financial powers of attorney in the world of law, we know those are probably the most important documents in your estate plan. And they actually have an indirect effect on your loved one with disabilities. So establishing your own financial or foundational plan, I should say, is really key. Then as part of that, establish a special needs trust, or what we call the third-party supplemental needs trust, or address those special needs issues with regard to your loved one and how they are going to receive assets. Calculate your financial needs, all of those things. Do projections with the advisory team. If you do not have an advisory team, let us help you get one. And really think about your retirement assets. If you're a person or a couple that has large retirement assets, we want to think about how best to leave those to your loved one with disabilities. And generally speaking, they are going to be exempt from the Secure Act, and understanding that. We want to get our minds around public benefits and make sure that our trustees have this information and that they are signing off on this, that they understand it. We want to think about the future and use our imagination. It's hard to do that when you have no time to think. We want to give you that time in our conference room spaces or by Zoom meetings, whatever is best for you, given your lifestyle, to get our minds around all of these concepts as we build. Start thinking about who the advocates will be. Start thinking about who the trustees will be. Start thinking about who the trust protectors are going to be. Start thinking about our collaborative team and who that's going to be. And then, of course, making your estate plan kind of centric or special needs centric to your loved one and your family situation with your disabled loved one. So that goes without saying. So with all that said, we want to talk to you. There's no cost to meet with us, but there is an attorney-client privilege. So our consultations generally are no cost to decide what you want to do, to get guidance and then move forward. An estate planning questionnaire is really a key issue. It's a lot of information that we're asking you to share. However, we want you to understand, because there is an attorney-client relationship, because it's confidential, there is nothing to fear, even though it's a very strange thing to come to complete strangers and share information such as this attorney-client relationship. So there's nothing to fear, and we encourage you to kind of think about what's holding you back. We're here to help you. We're here to counsel. Bring any estate planning documents that you already have. If you've done some planning years ago, please bring it. We would like to copy it or scan it and review it, give you our advice on it, and really look at what do we do from here. Again, thinking about your advisory team. Do you have a financial advisor? Do you have a CPA? Do you have an advocate? Do you have a life insurance professional? If you don't, we want to help you get that team in place. Make questions, write down your questions. We love questions. Even though we didn't get a lot today, we still might get a few before we stop. And again, the last thing is, our goal is to be here for you, to honor the opportunity that we've been given to be counselors, and to really help you identify what your goals are and give you peace of mind, and be encouraging that once you get a plan in place, no matter how good it feels, you do need to revise or visit that plan again in the future as you get older, as your fiduciaries get older, as your loved one gets older with disabilities, and as things change. If we update throughout lifetime, we will always win in the end, because we have kept on top of things as life changes. So thank you so very much for sitting through all of that. I'm going to just go to our last slide and turn it back over to Jeff. And it's 11:04. Hopefully we've been a little very efficient, hopefully, and hopefully you've garnered a lot out of this. Take away the substantive information that will be meaningful, and use this presentation, which I know Jeff has provided to you. Use it as kind of a mini masterclass. Put it on your bookshelf or in your desk, and just know this information is about 90% more than most people know about this subject, and use it as a reference tool. I wish you a very happy day and week ahead. Jeff, I'm turning it back to you.
Well, thanks, Steve. A great overarching presentation about a really important topic. So thank you so very much. So for our attendees, now is a great time to get your questions in to Steve. For our presentation, sometimes we have one question, sometimes we have 20. It really just depends on the audience. So any final questions, go ahead and get those into me, as I have a couple of final words. So for our returning attendees, as you know, and for our new attendees, I would send out a follow-up message with a lot of hopefully substantive information that's going to be of help to you. And for this presentation, it's a good amount, including our video from today and our presentation slides. Also, the memorandum of intent template that Steve alluded to, a link to Kevin Urbash's book, a link to our questionnaire that's helpful in getting started with your planning, and links to several of the webinars that Steve alluded to, along with his supported decision-making article link, and much more. So some light reading for you this evening if you'd like to peruse that. As we look forward to our webinar series going forward, we have a busy August and September. And starting next Wednesday, we have Estate Planning Essentials with Shannon Werbeck. That's at 10 o'clock next Wednesday. Understanding Estate and Trust Administration on August 21st at 10 o'clock with Steve Elville. And then we have a special presentation on August 26th at 3 o'clock at Friends House Retirement Community with our principal attorney in Rockville, Lily Hummel. She's been invited by that community to talk about your legacy, a discussion about wills and advance directives, also in honor of National Make a Will Month, which is this August. If you knew that, there's a day and a month for everything, including making your will. So, and lastly, August 28th, trustee selection and how to choose the right one for you, which Steve talked a lot about today, and is also one of our more timely and important presentations that we offer here through our webinar series. So look forward to seeing you on those. Let's check for our questions, which we do have a couple that have come through here. And Steve, you were right. We waited till the last minute, but good questions here. Let's see.
All right.
First one, any quick thoughts on adults disabled at birth, currently working with no benefits, if may need them later?
Well, thank you for that. That's a very important question. I have met in my career some amazing older adults with disabilities who have, despite their disabilities, have worked extremely hard under not so easy circumstances for them. And so these are amazing people. And I'm assuming this person you're talking about, or persons are over 22 years of age, and they're out there working in the world. They're adults. The unfortunate thing about our system is that the waiver system, depending on what this person's disabilities are, the waiver system says that this person should have gotten into the system prior to age 22. So if they are not on means tested benefits and they are over age 22, and depending on what their disability or disabilities are, the issue is that they probably would not be able to get more than emergency supports. So I would strongly recommend that kind of person get into the Medicaid or waiver system if possible, if for no other reason than to get emergency supports. But this is going to depend on the amount of support you provide them and what is the support for them after your passing in the future, about whether they're going to be able to maintain what they do and how much support you provide now. So the answer is, unfortunately, even though Maryland has very robust supports for persons with disabilities, those supports are not so robust if that person is not in the waiver programs. So hopefully the governor or the state will open up more waiver slots in the future, but I'm making a lot of assumptions about this particular person, about their ability to qualify for waiver benefits. But generally speaking, you want to get them in the emergency supports if possible. And even if the person is never going to be on means tested benefits, you still, in my opinion, depending on the circumstances, could use a supplemental needs trust for various reasons. And it's going to depend on the world of support, of advocacy that you build for them, even though they may never be able to obtain means tested public benefits. With that said, if a person has a work record, they can no longer work and they become disabled, then they can, of course, avail themselves of Social Security disability and Medicare. And it's just going to be a question of, at that point, does the person have very subtle means tested benefits like heating subsidies or housing programs? So even though they may not be on the quintessential kinds of public benefits for special needs, they may have underlying various means tested benefits that still would require or suggest that they should have a supplemental needs trust.
Okay, thank you. I'm going to wrap two questions into one here. First, can you help if we live in Virginia? And then can you talk just a little bit about general costs associated with setting up a third-party supplemental needs trust?
Sure. Well, thank you for that. So no one in our office is at Elville and Associates here in Columbia, Maryland, is barred in Virginia. Now, sometimes we do work with Virginia clients by and through Virginia attorneys. Some people want us to be involved, but we always have to have a Virginia attorney review documents or advise about certain things about waiver programs or about Virginia special needs law. And generally speaking, the best thing for you, and thank you for this question, is to really be referred to a Virginia lawyer who is an expert, so to speak, in special needs planning or focused in special needs planning. So that's one of the things I guess we could help you the most with. And even if the lawyers that you're dealing with there are not, let's say, taking the same approach we are happy to collaborate with them. But the primary focus has to be someone who is barred in Virginia. But we do have many Virginia clients who want us to work collaboratively with other lawyers who are barred in Virginia. And the costs of special needs planning is going to depend on the firm. It's going to depend on the flat fee, generally speaking, not always, but generally speaking, going to depend on the situation and the flat fee that the person or that particular firm charges. So our firm charges certain flat fees for third-party trusts. Our firm charges certain flat fees and sometimes does not charge flat fees for first-party trusts, depending on the situation. But the one thing that I can say that our firm is committed to is we are committed to the special needs community, and we do not hold hard and fast on our fees. And where there are certain needs and someone has an issue with being able to afford the proper special needs planning, whatever that need may be, we always do our very best to try to meet that need, despite what our fee schedule is. And ma'am, or sir or ma'am, we're happy to send you our schedule of fees.
Thanks, Steve. Next question is, my son is currently part of the Maryland Autism Waiver Program. He turns 18 in November 2024 and will be applying for SSDI benefits for him. Should being on the waiver make it easier for him to get benefits once he's an adult?
That's a great question. I think, and you may have meant, I'm not sure, I think you may have meant that he'll apply for SSI at age 18, but I do think it does make it easier. I think that your child being in the waiver program, by definition, means that there are probably ample records available showing his disability or disabilities, and that is well documented. So I do think it makes it easier. And I will say that when you apply for SSI or whatever that is that you're doing, probably SSI at age 18, there are 3 ways of doing it. You can go to the Social Security office, which I don't recommend. You can do it by telephone, which I do recommend. Social Security will actually call you if you make an appointment, or you can do it online. So just know that get that process started. Don't despair if for any reason your child is denied, which hopefully they won't because of the proof that already exists of their disabilities. And many people get approved on the first round. Don't believe that the negative stories, but certainly there are challenges. So if your loved one gets denied on the first round, remember there's a redetermination period, and you may be able to nip this in the bud at that time without having to go to the 3rd stage, which I'm just summarizing as the administrative hearing stage that could take quite some time. So yes, I do think probably the medical records that your son already has in place will speak very loudly about his disabilities for SSI.
Okay. Next question is, can UTMA account funds be transferred to ABLE or special needs trust so they don't become resources of the child that prevents public benefits when they turn 21?
Well, that's a great question. My general off-the-cuff response would be those funds probably have to go into a first-party trust because those funds are basically irrevocable and earmarked for the person with disabilities. So I think it's going to be a situation where we would take a look about how long this UTMA account has been established, the whole situation surrounding it, and try to decide should we petition a court, and if we do, should we just move those into a first-party trust, or is there any way this money can be used for the person in a way that and it sounds like it probably wouldn't be this case, but somehow get that money into a third-party trust. But I think just hearing you, it would probably have to go to a first-party trust because it is irrevocable and it's technically in the name of the person with disabilities. And the thing to take heart about there is, depending on how much is in that UPMA account, remember, if you have a first-party trust and your beneficiary is young, which it sounds like they are, chances are you're going to use that first-party trust money during that person's lifetime, and there will not be a payback to the state of Maryland. So all is not lost just because we may have to use a first-party trust.
Okay, thank you. So it looks like we have just a couple more here, then we'll wrap up. If planning to move to another state in the near future, should I wait then to do trust, will, etc.?
Great question. So if you're planning to move to another state, just remember that your will is valid in any state as long as it was executed validly in Maryland or wherever you live. And remember that if you move to a new state, your will should be valid and your powers of attorney and advance directives are going to be valid, but I would have those updated, the powers of attorney and advance directives, if you move to a new state. If your special needs trust that you create is a Maryland trust and you move to another state, that trust can move with you, especially if it's a standalone supplemental needs trust, which is a preferred option for a lot of people. It's a standalone trust and the location is Maryland, the state law is Maryland, but now you move to another state. So that trust can be updated in that new state to change to that new state's laws and to be situs or located in that state. So I think it's just a question of timing. If you feel emotionally the time is right, I would go ahead and get squared away on your estate planning now, and I wouldn't wait. But if you did wait, hopefully you are young enough and you won't need these documents to support you. But I guess in theory, you would do it now and then move to the other state and then have the documents adjusted once you move to the new state.
Okay. Next is a little specific, but see if you have some thoughts on this. Son was 21 at the time of accident creating a disability. He was working and had income. Which parent's income, or does the child get the benefit of both parents of the 50% and then 75% on death? The parents have been divorced since son was age 9.
Well, thank you for that. I would have to see more specifics, and of course, this can't be a technical legal answer, but it sounds like your son might have become disabled, unfortunately, prior to age 22. So if that's documented, now the question becomes when the parent retires, the first parent that retires will trigger the disabled adult child benefit, and then I'd have to check my Social Security rules to see if there's an adjustment when the second parent retires, if that second parent retires with a greater benefit. So my guess is it's the greater benefit, but the first person to retire will trigger that disabled adult child benefit. So that's what I would do now if I were you, is I would start looking at this situation, if you haven't already done so, and just confirm with Social Security that based on what we know now, your child would be a disabled adult child when one of the two of the divorced parents does retire.
Okay, very good. Why do you recommend a standalone special needs trust? I'm now concerned because my son's special needs trust was created with the revocable trust that was created within my trust.
Well, I'm glad you asked this question, so I'll spend 1 or 2 minutes here explaining it. So there are two types of third-party trust approaches. One is to do what I understand you did, which is you created a revocable living trust, and the supplemental needs trust is embedded within that trust. And then at your death, that supplemental needs trust gets created from the embedded state it's in there in that revocable trust. That is a third-party trust, no matter who says otherwise. That is definitely a valid third-party trust. There's another approach that would say we should create the standalone supplemental third-party trust now. And there's probably 3 reasons why someone might create this. Now, as I describe these 3 reasons, it's important to remember that an embedded third-party supplemental needs trust versus a standalone supplemental third-party trust is no different in regards to the protection. or the purpose of the trust. There is absolutely no difference. It's a question of approach. So the person who would use a standalone trust is a person who either, one, has family members that if they were to die first, they might, or they do have plans to fund the trust or to leave the disabled child something, and they need a place to leave that money. That's the third party trust that stands alone. That person would be able to leave an inheritance to this child in their third party trust. So the trust has to exist now for them to have that happen, because they could die before you. The second reason why someone would consider having this is if you yourself were going to contribute to it during your lifetime, and you may not have any plans to do that. So if you yourself are going to contribute, you will need to establish this during your lifetime so that you can make contributions, or maybe just emotionally you feel good about putting some money in that trust and seeing the permanency of it. But certainly you do not have to do that, and the embedded supplemental needs trust is fine. The third reason is really more of an esoteric reason, and I guess maybe a utilitarian reason, and that is if I were to have a solid, tangible trust in my hands, because I created it during life. I can see it, I can feel it, and when I pass away, my trustee can see it, feel it, hold it, and amend it, review it, and really have it there as life goes by. That, technically speaking, whether it's a general needs trust or a special needs trust, that standalone trust that the trustee can deal with tangibly is going to be more effective in a certain way than the old trust that was buried back in your revocable trust or will years ago when you passed away. So having that standalone trust is theoretically better, but there's no question that either one of these approaches is the same protection for public benefits and all of those things. It's exactly the same purpose. It's just a question of approach. I hope that helps.
Steve, thank you. Very helpful. And we'll have one more, then we'll close for the day. Could you explain a waiver program or provide any resources where that information can be gathered?
Yes. So what I would do in my own simple way of thinking, and I want to caveat this answer by saying that there are those who might explain this in a different way, but in my simple way of trying to convey this to clients, I would say this. Think about Medicaid and the delivery of Medicaid services in three different categories. In this category, we have what I might call community-based Medicaid. I live in the community, I have limited resources, I have limited income, and I need housing, I need Medicaid benefits for medical, I need all kinds of Medicaid benefits because I'm a person of limited resources. That program or those programs are unlimited. State and federal programs mandated that they have to be unlimited by the federal government based on certain guidelines. On the right-hand side, I might argue that long-term care benefits. So we have Medicaid community-based benefits, and over on this side, we have Medicaid long-term care benefits. I'm in a skilled nursing facility. I cannot pay $14,000 a month for my long-term care, and the state of Maryland mandated by the federal government that these benefits have to be provided unlimited so long as I am eligible financially and residency wise and so forth. And medical level of care, I will get those benefits unlimited. So we have unlimited benefits on both sides of the equation. Now in the middle, I might argue this category is what I would call the means tested programs or the waiver programs for people with brain injury or disabilities, developmental disabilities, for example, DDA waiver benefits, autism, the adult daycare waiver, the older adults waiver, which is called the community options waiver. And there are many different waiver programs. And these waiver programs, unfortunately, are limited. The state is allowed and states are allowed to limit these benefits. So for example, in my opinion, Delaware and New York have much more robust waiver programs, generally speaking, than Maryland does. But in the middle there is this waiver category, let's say, the waiver program, such as the DDA waiver program, not knowing the disabilities or limitations of your loved one. let's say they were eligible for this program, they would have to be in the program prior to a certain age, 21, and we want to make sure that people are getting their loved ones into these programs. And once they're in the program, now that program provides them with basically lifetime benefits, for better or for worse. Some of you know those benefits are very good. Some of you are not happy with those benefits, and some of you are using the self-directed waiver to conduct your own waiver program with managers. So this is what I mean by the waiver programs, those programs that the state can limit and not provide on an unlimited basis. That's what I'm referring to.
Steve, thanks for a great presentation. Thanks so much for your time. Really valuable information. To our attendees, thanks for your time as well. And we'll see you in our office hopefully soon, and also on the Elville webinar series again in the coming weeks. Have a great day, everybody. Take care.